Yes, Mr. Rossi.
May it please your ladyship, I appear for the appellant with Mr. Luckhurst and Professor Webb. My learned friends Mr. Lewis and Mr. Legg appear for the respondent.
Yes, thank you.
My lady, in terms of documents, the court should have a core bundle, a supplementary bundle, an unagreed documents bundle, 2 volumes of joint authorities.
2, 3, we've got 4.
Oh.
In A4 it's 4.
In A4 it's 4, I'm sorry. In A5 it's 2, which is why I've got them. In terms of written argument...
extra reading to do if you've only got 2.
Didn't make the reading any easier, my lady. In terms of written argument, there is, of course, our skeleton argument in the core bundle at tab 3, page 28.
Yes.
Mr. Lewis's skeleton argument at tab 4, page 53. And our additional skeleton argument dealing with the unagreed documents bundle, which is in that bundle at tab C1.
In the core bundle, C1?
No, it's in the unagreed documents bundle,
yes, of course
C1.
It is. Yes, I have read it. Yes, I couldn't remember where it was.
In terms of timing,
yes,
my lady, Mr. Lewis was most insistent to me this morning that he wants at least half of the time. I'm going to do my best to finish by 12:45 to allow him to have that, leaving me 15 minutes at the end of the day to try and reply. And as I say, I'll do my best to hit that target.
Well, Mr. Rossi, if it's any help, so far as any argument about the unagreed bundle, we were conscious that time was going to be tight today. And we would, our view at the moment is that we'll consider it de bene esse. But which we seem to us, I've seen Mr.
My lady, yes, that
does
was
seem to us to be the most sensible way. But
I'm very
perhaps you could just clarify the purpose that you say you would wish to put the unagreed documents to.
It's actually Mr. Lewis.
I mean, sorry, Mr. Lewis. What the
my lady,
just in a couple of sentences, otherwise we end up having the argument we're trying to avoid.
They support the draft re-amended particulars of claim. That's all that's in the unagreed bundles. And in fact, with some perspicacity, my learned friend and I had already agreed that, subject to the court's better view, we would in fact treat it de bene esse.
Sorry, when you say they support the draft re-amended points of claim, do you suggest that they provide evidence that the draft re-amended points of claim are true?
There's a letter in support, my lord, dated the 26th of September. But
there's a letter that has 3 paragraphs, if it's the one I'm thinking of, that explain the change of position, if I can put it that way.
That's exactly. That's all there is in support.
And that, you say, is evidence we should take into account?
Well, certainly, our position isn't that the draft re-amended particulars are evidence at all. They don't come as evidence. They're simply part of the pleadings, and they are certainly not with any of the Ladd and Marshall type of criteria.
I mean, does it amount to anything more than this new material shows the case that we now wish to run?
Precisely.
It's no more than that.
It's no more than that. Say that it supports the fact that it's not a contrivance.
What supports the case that it's
the
not
letter.
a contrivance? The letter. Right, thank you.
Thank you. That's helpful.
My lady, treating those matters as before you de bene esse, it seems to us that there are 3 questions for the court on this appeal. The first question is whether the pre-abdication allegations set out in the original particulars of claim fall to be characterised as acts carried out by the appellant in his public capacity for the purposes of Section 14 of the State Immunity Act. The appellant respectfully submits that the judge was wrong not to so hold. The second question is whether the proceedings as constituted by the original claim form and original particulars of claim were proceedings in respect of personal injury caused by an act or omission in the United Kingdom for the purposes of the Section 5 exception under the State Immunity Act. And the appellant submits in that regard that the judge was entirely correct to conclude that they were not. And the third question is whether it was open to the respondent when before the judge to seek to strengthen her hand on the first of these questions, the Section 14 question, by proposing unformulated amendments to her particulars of claim in the informal manner which occurred, and whether it is now open to the respondent before this court to seek to do so in respect of both the first and the second questions, the Section 14 and the Section 5 questions, by reference to further proposed amendments and further evidence underpinning those proposed amendments, which she says she has, but which she is yet to deploy. And the appellant submits again respectfully that the judge was wrong to have regard to any proposed amendments when the matter was before him, and that this court should itself refuse to consider, when it comes to giving its judgment, any materials not properly before the judge, obviously looking at them de bene esse as we go for the purposes of that third question. Turning then, my lady, to the first question, the Section 14 question by reference to the case as originally framed and as before the judge. The appellant's case has three stages to it. The first is that the appropriate test for determining whether an alleged act is to be characterised as performed in an individual's public capacity is whether it occurred under colour of authority. Secondly, the pre-abdication allegations in issue on this appeal should have been so characterised, having regard to the way they were put in paragraphs 16 to 23 of the original particulars of claim, and to other equally specific and express passages in that pleading. This was, we say, alleged to be conduct by the sovereign using the head of the intelligence services and intelligence operatives. That is, we say, classic terrain for characterisation as conduct under colour of authority. So that's the second stage. And the third stage is that we submit that the judge's reasoning on these issues was flawed in a series of material respects. He failed to identify the correct test. He misunderstood the guidance provided by domestic and international law, and he misinterpreted the particulars of claim in applying the test he did identify, wrongly finding ambiguity where on a proper analysis there was none. And taken together, my lady, those three stages embrace each of grounds 1 and 4 of the appellant's appeal. So stage 1, the appropriate test first. This is addressed in our skeleton argument at paragraphs 24 through to 28, that's core bundle 36 to 38. And as I've said, we submit the test is whether the act, when considered in context, is properly characterised as occurring under colour of authority. That is the test, we say, which is established and explained by Jones in the House of Lords, by Circus at first instance, and by Al-Attiya at first instance. And it's supported by the International Law Commission's articles on the responsibility of states for internationally wrongful acts. And it also appears, my lady, as you will have seen, that in the light of a series of paragraphs in the respondent's skeleton argument, in contrast to how the matter was argued below, it appears that that test is now common ground.
It comes also from Lord Gough in Pinochet number 3, doesn't it?
It does, my lord. It does, my lord. Notwithstanding that common ground as to the test, my lord, my ladies, I'd like to look briefly at those authorities first, if I may, both for the purposes of the Section 14 test and how it is to be applied, and so far as Al-Attiya and Circus are concerned, for the light that they cast upon the third question I identified at the outset, namely the appropriate approach when a party facing a plea of immunity seeks to amend their case in response to it. So Jones, my lady, is in my bundle 1. It's tab 12 of the authorities bundle in any event.
It's our bundle 2, I think.
Thank you. Now, as the court will know, it's page 550. As the court will know, this case concerned allegations of torture against Saudi state agents, and Lord Bingham and Lord Hoffman each gave speeches which were agreed with by each other member of the Judicial Committee, each concluding that the claims were indeed barred by state immunity. And there are 6 particular passages in those 2 speeches that I'd like to draw to the court's attention, 4 from Lord Bingham and 2 from Lord Hoffman. And they're cited by us for reference at paragraphs 24 and 28.1 of our skeleton argument. First, from Lord Bingham's speech at paragraph 12 on page 561, just in the internal pagination 281 between letters G and H. A state may claim immunity for any act for which it is in international law responsible, save where an established exception applies. Secondly, in the same paragraph, we get Lord Bingham's citation of the ILC's then draft articles on state responsibility, to which I'll come. But just to preview the points we make in that regard by reference to what Lord Bingham says here, we have reference to the notion of colour of authority at 282b, just over the page, where the ILC make it clear both that ulterior or improper motives are irrelevant to the question of capacity in which a person acts, and that where a person acts in an apparently official capacity or under colour of authority, the actions in question shall be attributable to the state. We have reference to Article 7 of the ILC's articles at 282c, making the point that conduct is still attributable to the state, even if the state agent concerned is acting in excess or in breach of that authority. And that's a direct answer, which I'll come to in due course, a direct answer, we say, to the respondent's apparent argument that if conduct is unlawful, it cannot be characterised as under colour of authority and must be treated as non-attributable and a frolic. Then at 282F, we have the key question distilled into asking whether the state agent was acting with apparent authority. That's the second passage. Thirdly, from Jones, I'd ask the court to note the basic point made by Lady Fox and endorsed by Lord Bingham at 288H to 289A, page 568 of this bundle, in addressing any merit points that may be made on behalf of the respondent. And the point is a simple one. Immunity is a procedural bar.
Sorry, which paragraph are we at, Mr. Rossi?
It's towards the foot of, right at the foot of 568, my lord, my lady, by letter H.
Got it, thank you.
Immunity says nothing about the lawfulness or morality of conduct alleged. It merely diverts allegations of breach of the law away from adjudication by foreign domestic court, foreign municipal courts. The fourth point from Lord Bingham, and the final point from Lord Bingham, my lady, at page 570 to 71, at paragraph 33, going over the page to 291A, Lord Bingham emphasising that the application of state immunity is not discretionary. Where it applies, it is a mandatory bar. And I emphasise that because as we contend under ground 4 of this appeal, and as I'll seek to explain when we look at the judge's reasoning, at least part of his approach apparently involved a discretionary exercise, having regard to his conclusion that some allegations would be proceeding in any event. So that's Lord Bingham, my lady. Lord Hoffman is the fifth passage I wanted to emphasise, comes from Lord Hoffman at paragraph 66 on page 578. And we have the basic proposition, the decisive point, ultimately in Jones, that the same immunity which protects the state also protects the individuals for whom the state is responsible. And then sixthly, and perhaps of most direct relevance for present purposes, we have paragraphs 74 through to 78 of Lord Hoffman, beginning at page 580, where we have Lord Hoffman's summary of how that class of persons for whom the state is responsible is identified. At 74, we have this: it has until now been generally assumed that the circumstances in which a state will be liable for the act of an official in international law mirror the circumstances in which the official will be immune in foreign domestic law. And then this for the crucial test: the state is liable for acts done under colour of public authority, whether or not they are actually authorised or lawful under domestic or international law. The example of the arbitral case of Mallon, to which I'll return when we look at both Circus and the judge's judgment, is then cited by Lord Hoffman at paragraph 75. At 76 to 78, we have reference again to the ILC articles and emphasis again on the irrelevance of ulterior or improper motives, or the fact that an abuse of public power may be involved. And the last sentence of 78 again makes the central point that I've made from Lord Bingham's speech, in which we emphasise in our skeleton at 28.1, about immunity tracing principles of attribution and state responsibility. As Lord Hoffman puts it here, a state will incur responsibility if one of its officials, under colour of authority, tortures a national of another state, even though the acts were unlawful and unauthorised. To hold that for the purposes of state immunity he was not acting in an official capacity would produce an asymmetry between the rules of liability and immunity. Lord Bingham agreed with Lord Hoffman agreed with Lord Bingham, and each of the other members of the committee agreed with both of them, my lady. So that's Jones and the guidance we get from Jones. And then we then see its application, we say in a helpful way, in the two first instance judgments that I mentioned, Al-Attiya and Circus. And Al-Attiya is the one I wanted to go to next, which is tab 18 of the authorities bundle, page 700. Perhaps in bundle 2 of the court's bundles. Thank you. And as I said earlier, this is a decision of Mr. Justice Blake at first instance in the context of allegations of torture, trespass to land, property confiscation and detention. And the key passages we rely upon are those at 22 to 27, which we've set out also in our skeleton at paragraphs 25 to 26. At 22 to 24, we have Mr. Justice Blake explaining the importance of the pleaded case before the court in considering issues of immunity, and the inappropriateness, we say in principle, of permitting late and fundamental reformulations of a claim in an endeavour to avoid state immunity. He notes at paragraphs 23 and 24 that there was before him no application to amend, no draft amended pleading, despite the 4 months that had elapsed since the immunity application was issued. That instead, the contemplated amendment appeared to have been developed ex improviso in an endeavour to avoid immunity. Now, we respectfully submit that the same was the case when this case was before Mr. Justice Nicklin. Here too there was no application to amend, there was no draft pleading, and the first proposal for an amendment came during the course of oral submissions, some 6 months after the state immunity application had been issued. Back to Mr. Justice Blake at paragraph 25, there's the important passage which we quote in our skeleton at 25. There is no judicial authority on how a former Prime Minister of a sovereign state could be sued in a private capacity for inducing breaches of duty by other public officials, resulting in torts being committed against the claimant. It is difficult to see how the two hats can be severed, and how the alleged private motive in inducing the torts can be separated from the public office that gave the defendant the status and ability to direct others and issue instructions. And we, of course, say that the same applies here. There is no judicial authority, aside from Mr. Justice Blake now, and as we'll see, Mr. Justice Carver in Circus, on how a former sovereign could be sued in a private capacity for inducing breaches of duty by other public officials, resulting in torts committed against the claimant. And it's just as difficult, we say, in the present case, to see how the two hats can be severed. We rely also on paragraph 27 of Mr. Justice Blake, set out again in our skeleton at 26, where he finds that any determination of the claim before him would engage state immunity because it would directly challenge the good faith of the public officials there referred to. And it was not a case, as he said, where the acts of a foreign state under challenge are the unwitting outcome of a malicious use of process by a powerful citizen. So too here, we say, any determination of the present claimant's claim would directly challenge the lawfulness and propriety of at least General Sands Roldan's conduct and the unnamed CNI operatives referred to in the originally pleaded case. And it cannot be said, we say, that the alleged acts of the general and those operatives were the unwitting outcome of the appellant's conduct. On the claimant's case, they were directed and controlled by the appellant, and the general was, on the claimant's pleaded case, deeply implicated in their planning and execution at every turn, as were the CNI. So that's Mr. Justice Blake. Circus is next, and that is tab 30, which I suspect is in the last of the court's bundles. It's page 1431. And it's perhaps the closest case to the present context, as it too concerned a former head of state, this time the former president of Ukraine. And the case concerned a claim brought by a Ukrainian businessman and his companies against the former president and a former governor of the National Bank of Ukraine. And the claimants alleged that the defendants, including the first defendant, the former head of state, President Poroshenko, had conspired to use their influence whilst in office to deprive the claimants of their assets, and that they had acted in their private capacities for their own personal gain. We get all of that from paragraphs 20 to 21 of the judgment. Now, Mr. Justice Carver held that the claims were barred by state immunity and no appeal was brought against his decision or indeed against Mr. Justice Blake's that we've just been looking at. The judge began with the correct analysis, so the correct approach we respectfully submit, of carrying out a detailed analysis of the claimant's pleaded case, as set out in the original pleading. And in his case, he had the luxury of draft re-amended particulars of claim which were before him, consented to by one defendant, not consented to by another. And he looked at those too. And that's in paragraphs 36 through to 42 for the court's reference, where he carries out that analysis. Now, in carrying out that analysis, the judge noted, I think this is paragraph 39, the judge noted that the claimants had sought to narrow their originally pleaded claim in an attempt to avoid characterising the conduct complained of as involving public acts and to defeat the pleas of state immunity which had been raised. Yes, it's page 1441, paragraph 39. He then turned, most materially for our purposes, to the relevant legal principles, beginning at paragraph 43. And I'd like to emphasise again a number of the passages in his judgment, if I may. So paragraph 43, page 1444, he emphasised that the State Immunity Act represented a complete code, such that if a case did not fall within one of the exceptions to Section 1 immunity, then the state was immune. At 44 to 45, he explained the concept of head of state immunity and its application even after a head of state had left his position in respect of acts performed as head of state which were engaged in, and again the key words, under colour of or in ostensible exercise of authority. Paragraph 48, page 1446, he emphasises, as we've seen from Jones, the availability of immunity regardless of the lawfulness, constitutional propriety, or authorised status of the conduct under the foreign state's laws. And then at 49 to 53, and citing Lord Wilberforce in E Congresso and a number of other authorities, Mr. Justice Carver explained that in determining the critical question, as he described it, of whether the conduct complained of was engaged in under colour of or in ostensible exercise of public authority, rather than as a purely private act, it was necessary to consider the character of the alleged act in the whole context in which the claim was made. At 54, he then gave a series of examples of cases where it was relatively easy, series of examples from the case law of cases where it was relatively easy to characterise the conduct in issue as private in nature. And if your ladyships and your lordship would cast your eye down those, you'll see, we would submit, none of them are remotely comparable to a case such as that before this court. None involved the conduct of the head of state giving instructions, as it's alleged, to the head of the intelligence services. None of them involved the conduct of such a person, the head of those services. None involved search and surveillance operations by intelligence service operatives overseas, let alone covert operations. None involved a situation where the relevant conduct could, as we submit, adopting the analysis of Mr. Justice Carver, and indeed of Mr. Justice Blake, could only occur because of the influence enjoyed by the relevant head of state and flowing from that status. Intelligence service operations, as the court will know, are a classic, described in Pinochet as a paradigm example of sovereign conduct. Similar point made by Lord Sumption in Belhadge. Back to Mr. Justice Carver, paragraphs 55 to 57. Mr. Justice Carver pointing again to the irrelevance of ulterior or improper motives, citing Lord Bingham and Lord Hoffman in Jones as he did so. And then paragraph 57, Mr. Justice Carver citing Al-Attiya. And then going on after this recitation of principles, going on to apply the principles to the facts of the case before him. And like Mr. Justice Blake before him, his approach to the claimant's ingenuity of pleading in that case is, we say, of direct assistance in the present context. At paragraph 67 to 69, he summarised the way the claimants sought to put their case. And he summarised their argument as being that the defendant's conduct could not be characterised as governmental or sovereign because they were not themselves purporting to exercise any relevant official duties, powers or functions in acting as they did. And the claimants contended the defendants were acting in a way that any private citizen could act, and acting for their own personal benefit. Now that is very much the same argument, we say, on analysis that's advanced by Mr. Lewis in this case. At paragraph 71 through to 82, the judge then explained why he rejected those submissions under the heading public or private acts. At 72, he noted the claimants' narrowing of their case by way of amendment, but he then underscored the importance of considering what remained in context. At 75, the judge characterised the claimant's amended case in arguing that the defendants, including the former president, had done no more than any other private citizen could do. Mr. Justice Carver characterised that argument as involving a wholly artificial construct. The echoes, we say, with the claimant's case here are clear. It is a manifestly artificial construct to start with a case with multiple references to the head of Spanish intelligence and to Spanish intelligence operatives, falling under the influence of the King of Spain, culminating in the pleading on the claimant reporting such conduct to the British security services, and then to delete all references to those operatives and aver that the head of intelligence somehow acted in a private capacity, particularly when that course contradicts not just the statement of truth that the respondent put on her own pleading, but an earlier sworn affidavit she had deployed in Spanish proceedings. Now, paragraph 76, Mr. Justice Carver endorsed the approach of Mr. Justice Blake in the earlier Al-Attiya judgment, and the passage I've just emphasised, in which Mr. Justice Blake had characterised an attempt to avoid immunity by severing the conduct of powerful individuals who held high office from their status as an illegitimate exercise involving an artificial distinction. At 77, Mr. Justice Carver drew attention to the fact that it was the defendant's very holding of that high office which enabled them to use their influence. At 78, Mr. Justice Carver described the claimant's counsel as having to dance on a pinhead in the attempts to evade state immunity. We respectfully submit the respondent is in a similar position here. Mr. Lewis was kind enough just before we started this hearing to indicate to me that he would be correcting various assertions in the letter of the 26th of September about when the claimant knew what in relation to various allegations. But further illustration of the twists and turns in the respondent's case, which we respectfully submit have no place in a rigorous application of state immunity principles. Then at paragraph 79, we have Mr. Justice Carver emphasising that it was in any event wrong in principle and contrary to authority to take an overly narrow approach to a state immunity issue and to treat it as divorced from context. Applying that guidance here, we say it's wrong in principle to focus only on the last-minute proposal floated in oral argument before Mr. Justice Nicklin and permitting a narrow and tactical repleading of a case, and to allow it to occupy the field and determine the outcome, regardless of what in context, on any sensible view, the relevant parts of the claim are all about. Now, finally, on the key authorities, my ladies, my lord, before turning to the particulars of claim themselves, the International Law Commission's articles, some of which we've already seen reference to in Jones. And I think in the interest of time, I can actually take these from our skeleton argument and just draw the particular passages that we rely upon for the court's attention in that way. There are paragraphs 28.2 and 34 of our skeleton argument, pages 37 to 38 and 41 of the core bundle. And if the court wants to look at the originals, they're in the authorities bundle at page 1601. We have the irrelevance of ulterior or personal motives underscored in paragraph 13 of the commentary to the Article 4 of the articles, that's skeleton 28.2. We have confirmation from Article 7, in the same paragraph in the skeleton, that even conduct in excess of or in breach of authority or instructions can be attributed to the state and so attract immunity. And we have confirmation, this is skeleton paragraph 34, we have confirmation in the commentary to Article 8 of the articles that the conduct of private individuals can still be attributed to a state if in fact authorised by a relevant state official, including as an example where individuals or groups of private individuals are instructed to carry out particular missions abroad. And the example given in the commentary is in relation to the United States activities in Nicaragua and deployment of private contractors and private mercenaries, still leading to attribution, and still, by virtue of the symmetry that we've seen described by Lord Hoffman, leading to immunity. So those are the key authorities, my ladies, my lord, and we respectfully submit, provide a very clear path to analysis of the correct outcome in this case. And that's the first stage, as I said at the outset, to the first question. The second stage, of course, is how do those authorities apply to the particulars of claim? And as you know, I'm focusing at the moment on the original particulars of claim. We say, focusing on the allegations in issue on this appeal, the pre-abdication allegations, paragraphs 16 to 23 of the particulars of claim, viewed in context and having regard to personnel, means and timing, the conduct alleged can only be characterised as occurring under colour of authority and so satisfying the relevant test. That is the conclusion we respectfully submit, which must follow however vigorously that characterisation is objected to and however many times the claimant asserts that private individuals can engage in acts of surveillance and so forth. Private individuals are simply not in a position to influence the heads of intelligence services. They are not in a position to arrange and direct and deploy covert operations by intelligence services operatives overseas. And as I said a moment ago, the conduct of intelligence agencies is the classic terrain of sovereign states and sovereign conduct as a matter of both common sense and authority. Now, this is addressed in our skeleton argument of paragraphs 8 to 10 and paragraph 27, and the court has the particulars of claim themselves at tab 11 of the core bundle, page 118. And as I said earlier, supported this document by a statement of truth from the respondent at page 145. The material paragraphs begin, in fact, at paragraph 4, where page 119, with the summary, where it said that the defendant used his agents and those of the Spanish state and all their contractors to carry out some of the elements of the course of conduct complained of. So there's nothing ambiguous about that at all. It is a positive averment of state agent involvement, which the claimant herself has certified to be true. And the respondent's skeleton argument offers no comment at all on that allegation in the original particulars of claim. It is one of the allegations that exits stage left when the amendments are produced in April after the hearing. The detailed allegations in issue on this appeal, and as they stood before Mr. Justice Nicklin, are then set out, as I've said, at paragraphs 15 onwards under the heading The Course of Conduct. At paragraph 16, we have specific allegations against General Sanz Roldan, allegedly acting under the direction or with the consent of the appellant. And it's said here that over a 3-month period, from April to June 2012, General Sanz Roldan coordinated a covert operation involving CNI agents. It's said in terms that he used armed operatives to enable a CNI team dispatched from Spain to gain access to her property in Monaco, a team that it's then alleged needed 5 days to sweep the claimant's office and apartment. So again, on the claimant's detailed case at this point, there's nothing ambiguous, there's nothing unclear. The long-serving sovereign of Spain is allegedly directing the head of the state's intelligence services to carry out a 5-day search operation overseas using a team of CNI operatives dispatched from Spain for that purpose. At 17, the alleged objectives of the covert operation are set out. And they included, on a natural reading of this paragraph at least, the prevention of incrimination of the sovereign and the installation of surveillance equipment. Now, the respondent's skeleton argument, as the court has seen at paragraph 8.1, seeks to recast these paragraphs in the pleading as doing no more than pleading an inference of CNI involvement, stating that it was necessary, as it's put, it was necessary to plead an inference as to who the team was. Now, that's with respect not what these paragraphs do. There is no reference to inference, and there is instead an express, unqualified allegation backed by a statement of truth, just as there was in an earlier sworn affidavit of the respondents, including within it allegations of conduct by Spain itself. It's not understood why it was necessary, as the respondent's skeleton argument puts it, to make this allegation of state involvement at all, if it was not the claimant's case. All the respondent needed to do, for the purposes of her claim, was make an averment that persons acting under the direction and control of the king had been involved. What appears more obviously, we say, to have happened, is that the claimant has advanced what she believed to be the case in her original particulars of claim, see her statement of truth, and then she sought to abandon it once the state immunity implications of that case became clear. We also know from the particulars of claim when the respondent is relying on inference and when she isn't, because we've got a series of examples, not hard to find, much later in the pleading, paragraphs 50, 52, 30 and 33, all expressly seeking to rely upon inference in relation to conduct in later years. Nothing like that in paragraph 16 to 23 here. No suggestion of inference, instead unequivocal direct allegations. Paragraph 19 of the...
Just before you move on, you
Yes.
draw our attention to paragraph 17.
Yes.
And to one of the motives being to avoid anything which might incriminate the king.
Yes, my lord.
What's the relevance of that motive?
Well, it's irrelevant, my lord, as a matter of law, as we've seen. If there is an attempt to pray in aid, personal motives and so forth, we've got two answers. One, it's irrelevant as a matter of law. See Jones, Lord Hoffman, see the ILC articles. Two, even if that were not the case, even if somehow you could shoehorn in relevance of motive, it cuts both ways.
Well, that might be a private motive just as much as a public motive.
It might
So
be,
I'm
my
not
lord.
sure that it helps you, even if we're looking at motive.
Well, maybe so, my lord. But it's not difficult to see how an intelligence service, a head of an intelligence service, could properly be safeguarding the interests of the sovereign of a state as a matter of generality. But the key point on motive is that it's analytically irrelevant. But back to the particulars of claim, paragraph 19, we have an allegation against General Sanz-Roldan that in May 2012, while, as the claimant puts it in the last line of this paragraph, so it's a matter of context, the Monaco operation involving the CNI operatives was ongoing, the general threatened the claimant, with particular emphasis given to the general's official position. Now, in her response to this paragraph, in her skeleton argument, the respondent seeks to characterize this as an off-duty event. But that argument, we say, ignores the emphasis her pleading gave to the timing of this meeting, coinciding with the CNI operation underway in Monaco. And in context, we say, one cannot sensibly be separated or severed from the other. And as I'll explain later when addressing the third question about the new materials, this is another aspect, the claimant's case in relation to this alleged meeting, where the claimant's case, the respondent's case, has oscillated in an unsatisfactory manner. Now, I'll give the reference in due course, but just to flag the point now, in oral argument before Mr. Justice Nicklin, Mr. Lewis, no doubt on instructions, said that his client had reports that General Sanz-Roldan had admitted that his visit to London was undertaken in a private capacity. Now, those reports and that admission are one of the few things we've never seen reflected in any amended particulars of claim since. And it just illustrates again the real caution that has to be applied in considering amendments floated in this informal manner. So paragraph 20, my ladies, my lord, a further covert operation of some kind is alleged to have occurred at around the same time. Again, in context, we say, and given the nature of the allegations made, it too has to sensibly be seen as a further allegation against the CNI. And this is the point.
It's expressly pleaded.
It's not
46.1.
Exactly so, my lord. Not expressly pleaded in paragraph 20. I was going to go to paragraph 46.1 as suggesting that actually it is expressly pleaded. The very next line of my speaking note was to say, this is the point we make in our skeleton at 8.3, and if there was any doubt about its correctness, it's confirmed by 46.1 of the particulars of claim, where it is alleged, as my lord has seen, that the defendant and General Sands-Roldan used contractors and agents of the CNI to enter her premises in Monaco and in Villars. And finally, in this primary section of the pleading relating to this pre-abdication period, we have three further references to General Sands-Roldan set out in the particulars of claim at 21 to 23, including by reference to and bound up with the events in Monaco, which, as we've seen, expressly involve the CNI team. So again, impossible on any sensible approach to sever them in the way the respondent seeks to do. And again, the allegations right through this section of the pleading, not ambiguous and not said to be based on inference. Express, specific, and certified as true. So on their face, in the original particulars of claim, the allegations were necessarily of conduct occurring under colour of authority, having regard to the identity of the key players and the nature of the conduct, the sovereign, the head of the intelligence services, the CNI operatives. That is just not the territory of private acts and private actors. As Mr. Justice Carver put it in Circus and Mr. Justice Blake put it in Al-Attiya, it is difficult, we would say impossible, to see how the alleged private motives in inducing the torts complained of can be separated from the public office that gave the defendant the status and the ability to exert influence over public officials, to direct others, and to issue instructions. A private citizen could not have procured General Sands-Roldan or the CNI to act in the manner alleged. And again, as Mr. Justice Blake put it in Al-Attiya, any determination of these allegations would directly challenge the good faith of the CNI and General Sands-Roldan. Now, the respondent seeks to meet this case by saying that the colour of authority test is not met because of a lack of positive evidence on my side, or because the appellant, His Majesty, relies for his arguments on unjustified inferences. And she points to a series of matters, she says, as showing that the appellant can't rely upon the pleaded case. And this is all in 31 to 33 of her skeleton argument. First of all, it's averred that the appellant and General Sands-Roldan had a close personal relationship, evidenced by the General's visit to the United Arab Emirates since abdication, and the appellant's alleged 2019 statement that the General was his great protector and ally. Secondly, she relies upon her assertions that the conduct complained of allegedly continued after abdication. And thirdly, she asserts that covert operations of the kind set out in the pleadings cannot be treated as ordinary intelligence activities. And then finally, she refers to new allegations, which she wishes to introduce before this court, that the appellant used a private contractor in the intelligence and security sector to harass her. Now, none of those arguments, we say, on analysis are sufficient. As to the first argument, the close personal relationship argument, this depends in significant part on new allegations that the respondent wishes to introduce, which were not in the pleading before the judge. And that's an illegitimate approach for the reasons I'll come to under the third question. Furthermore, and in any event, the allegation that the appellant and the general had a close relationship and that their relationship endured in the years since abdication takes the respondent nowhere in meeting the case she has to. There's no basis for contending that they would have had any relationship at all but for the appellant's status in the material period we're concerned with. And the fact that the appellant and the general are alleged to have met since abdication does not alter the fact that the conduct alleged in paragraph 16 to 23 can only sensibly be characterised as having occurred under colour of authority for the reasons I've already given. There is simply no basis for suggesting that just because of a personal relationship, the general would have been willing to go off on a frolic of his own and deploy Spanish state resources as a personal favour based on friendship, rather than the king's status in public capacity. As to the second argument and the allegation that the conduct complained of continued after abdication, this also takes the respondent nowhere, because the allegations before and after abdication, as set out in the particulars of claim, are so very materially different in substance and particularisation. Before abdication, as we've seen, it's alleged that the general himself was heavily involved, including in meeting with the respondent, and that a team of CNI agents was deployed overseas on 2 occasions. That is what paragraphs 16 to 23 are all about. After abdication, the allegations become much more vague. They involve very few allegations against the general and are on analysis this time based on bare inference. And there are examples throughout the later passages in the pleading. Paragraph 42.4, there's a highly generalised assertion in relation to publications involving the general. 42.5, there's again a highly generalised allegation of surveillance by the CNI, but no reference to the general. And 43, further entirely generalised allegations with no reference to the general, based on unevidenced claims from a Spanish police officer. And that pattern of vagueness continues through 48 onwards to 52 of the particulars of claim. As to the third argument, that covert operations of this kind cannot be treated as ordinary intelligence operations, it's, we respectfully submit, quite unrealistic to say that the conduct of covert search and surveillance operations is anything other than the classic business of intelligence services. And as to the final argument, the unexplained emergence now of allegations involving a private contractor take the matter nowhere. And I say unexplained, I'll come to the detail when we address the third question. But all we've got by way of explanation is a statement that what's set out in the letter is being offered without waiver of privilege. We don't know what that means. In the letter, we've got an assertion that the claimant learnt of these allegations about the private contractors in May 2022. And we've now got Mr. Lewis's clarification that apparently it occurred a couple of months earlier, but no further detail than that. They certainly weren't in the original particulars of claim, so for the purposes of my first question, they're analytically completely irrelevant. But even if they were taken into account, they wouldn't help the respondent, because it's quite clear that even conduct on the part of a private contractor can trigger immunity if attributable to the state. So too here, the conduct of both the appellant and the Nicklin group, as the respondent would now have it, would be attributable to the state on the basis of the alleged roles played by both the appellant and the general, and would give rise to section 14 immunity. So that's the second stage of my argument on the first question. On its face, the allegations in this part of the particulars of claim do indeed involve allegations under colour of authority so as to trigger immunity under Section 14 of the State Immunity Act. It was on any sensible view being said that the appellant had used his position and influence as head of state to procure the state security services to harass the respondent, and that the general had done likewise. Now, that would no doubt have been an abuse of power by the appellant and by the general and by the operatives. But that would not stop Section 14 from being satisfied. So that takes me then to the third stage of this first question, the judge's approach, and what we respectfully submit to be the flaws in that approach. Now, the judge's judgment, the court has seen, is at, in the core bundle, of course, tab 8, page 87. And as I said earlier, we respectfully submit the judge failed to identify the correct test, that he misunderstood the guidance provided by domestic and international law, and that he misinterpreted the particulars of claim in applying even the test he did identify. Now, the judge's reasoning on the Section 14 issue, and there are other passages which, in his judgment which I'll have to address when I'll come to, but the judge's reasoning on the Section 14 issue is paragraphs 65 to 75. And we respectfully submit that every one of those paragraphs showed either that the judge found the question of functional immunity under Section 14 difficult in a way which should not have been the case given the clarity of Jones, Circus and Al-Attiya, or that he erred in his approach. At paragraph 65, he acknowledges that he found the issue more difficult than that of household immunity, the issue upon which this court refused permission to appeal in July. At paragraph 66, the judge drew attention to the fact that if this aspect of the immunity argument succeeded, it would only lead to the striking out of part of the claimant's claim relating to pre-abdication, pre-June 2014 conduct. And given his conclusions on the issue of household immunity, the case would be proceeding anyway. Well, subject to the other jurisdiction arguments, that's correct as a matter of fact, but irrelevant as a matter of analysis. We know, in fact, though, from what the judge says later in his judgment at paragraph 72, that this was a matter he took into account in determining the right approach to the issue of immunity before him. But that was, with respect, flawed as an approach. If part of a claim is covered by state immunity, that part of it must be struck out, regardless of what other aspects of a claim remain. There's no discretion. This is back to the final point from Lord Bingham's speech. There's no discretion, as we emphasise in our skeleton at 40. And this error goes particularly to what we characterise as ground 4 of our grounds of appeal. Paragraph 67 to 68...
Is that because immunity attaches to factual allegations rather than causes of action or proceedings as a whole? And if so, what's the authority for that proposition?
It attracts to... Immunity prevents the court from adjudicating upon any cause of action which would involve adjudication upon the foreign state. And that is what would be involved here in allowing paragraphs 16 to 23 to go forward.
Well, that's not right, because the cause of action can still be adjudicated on. It's just the particular allegations.
Well, I'm sorry, my lady, I expressed it inelegantly. The cause of action, as reflected in those paragraphs, cannot be adjudicated upon. Cause of action based on the post-abdication complaints can be adjudicated upon. So the cause of action in general terms of harassment can be adjudicated upon by reference to allegations which are not barred by state immunity.
So it's the factual allegation.
It's a factual allegation.
But it's the factual allegations by virtue of them being relied upon as elements of a cause of action.
Yes.
Does it follow then that if the appeal succeeds, it would be open to the respondent to make those factual allegations as the background to the post-application cause of action allegations?
Well, that would be a question that would have to be fought out. I could see that you might seek to bring in allegations which couldn't be relied upon as part of a cause of action as similar fact evidence, and the question will be whether or not they met the relevant test. And that would be a matter that would have to be debated at first instance. Our position would be if the test is striking similarity and one compares the vagueness of the post-application allegations and the very different players on the scene then.
Well, I understand you say that's for another day.
That's for another day. But that
what would be said against you is in deciding whether what happened later was at the instigation of the king, you look at what happened earlier, because that's the context. And if you established that what had happened earlier had taken place and was instigated by the king, that casts light on whether the inferences that it sought to be drawn later.
Well, yes, and that's for another day.
Are proper inferences, but then, that's for another day.
That's for another day. The only coherent approach to a state immunity challenge of the kind that this court is confronted with, we say, is to look at the allegations, decide whether or not they trigger state immunity. If they do, then they have to be struck out. Now, the field is then open, I would accept. The field is then open for the the respondent at first instance, to consider the course she wishes to take. She might seek to amend her claim, and there would then have to be a properly focused application, supported by evidence, which the court at first instance would have to consider, and would have to consider amongst other questions that it would have to consider whether it was all contrived and so on. So the court might also, I'm sorry, Mo.
No, maybe we don't need to go down this line, but the par inter pares justification for the type of sovereign immunity that we're looking at might suggest that this court should simply not investigate and pronounce judgment on alleged acts by a sovereign in the exercise of sovereign authority, or public capacity, to use a shorthand, and that actually the immunity attaches to the investigation of the acts themselves rather than to cause of action.
Yes, my lord, I don't think I can go that far because
not right.
I don't think it's right because, for example, in the asylum context, every day there is investigation of acts alleged against foreign states for the purposes of determining those asylum applications.
Well, that's in proceedings against third parties.
Yes, it is, but it's illustrating the point that the court doesn't have an independent. The court is not precluded in all circumstances from ever adjudicating upon the conduct of foreign states.
No, I quite understand that. But if it is the foreign state or the sovereign who is impleaded, then the par inter pares principle cuts in. Anyway, there we are.
It may well be, it's not for today anyway, but it may be. We'll have to consider where that goes.
Well, it may come into the Section 5 question, but there we are. We'll come back to that.
Yes, I'll come to Section 5 in a moment. So I was in, I think, paragraph 60. I was going to paragraph 67 to 68 of the judge's judgment, where the judge cites some important passages from E Congresso and Circus, but then fell into error by focusing only on the cause of action alleged by the claimant and the generic heading of the matters complained of, in each case harassment, and the dividing line between sovereign and private conduct, but critically failing to address the concept of colour of authority at all. And he concluded at 68 that the claim for harassment was not even arguably within the sphere of governmental or sovereign activity, as harassment is an act that any private citizen can perform. And in reaching that conclusion, the judge referred back to his own paragraph 50 and a passage from Lord Gough's speech in Kuwait Airways describing the ultimate test of what constitutes an act jure imperii as whether the act in question is of its own character a governmental act, as opposed to an act which any private citizen can perform. Now, the appellant submits that the judge's approach was flawed in each of the four respects we've set out in our skeleton at paragraph 29. The first error, and this is 29.1, is that it was wrong to focus on the domestic law cause of action, harassment, or a generic description of the conduct alleged, harassment. What was required was a direct focus on and consideration of the actual actions and conduct complained of in context. If that had occurred, if that rigorous analysis had occurred, we say the judge would have been bound to acknowledge that deployment of intelligence services by the head of state through the head of the intelligence services was very much within the sphere of governmental or sovereign activity. The second error, this is 29.2, was to reduce the test to whether the act in question was one any private citizen could perform. That was to oversimplify the test and to take Lord Gough's words out of context. If an act is one which no private citizen could perform and only a government could perform, it is of course a sovereign act. Entering into an international treaty would be an example that we've given in our skeleton. But if an act is one which both a private citizen and a government could perform, then in the light of Jones and Circus and Al-Attiya, further inquiry is required. It's necessary to consider the substance of the individual allegations in context. It's necessary to consider whether they're carried out under colour of authority. It's necessary per Circus to consider whether the defendant was only in a position to procure the involvement of other state officials by virtue of his own position and the ability to exert influence which it provided. And it will be necessary to consider whether the conduct complained of could be attributed to the state on the international plane. So that's the second error. The third error lay in the fact that, as explained in 29.3 of our skeleton, the judge's approach simply failed to refer to, let alone try to apply, the colour of authority test. And the fourth error, this is 29.4, if the judge was somehow treating the test of conduct in a public capacity as only being satisfied by governmental activity, that was a further error too. Many heads of state are entitled to the protection of Section 14, even though they have no governmental role at all. Now, it's right to say that at paragraph 69, the judge did turn to consider whether immunity could be claimed in respect of individual acts relied upon as part of the course of conduct amounting to harassment. And he said there that one of the difficulties of approaching that issue was that the claim was pleaded on several bases as to who it was that actually carried out the acts said to amount to harassment. But that, we submit, was very significantly to overstate the problem and to fail to have sufficiently close regard to what was actually pleaded in the particulars of claim. They were not ambiguous in any material sense. As I've already submitted, and as we've sought to explain in our skeleton at paragraphs 7 to 10, there were a series of express, unequivocal pleas of state agent involvement, all of them backed by the respondent's statement of truth, all of them consistent with her affidavit evidence. Paragraph 70, the judge, having got the factual premise wrong by referring only to one generalised paragraph in the particulars of claim, and not the detailed, specific and express allegations that we've seen at paragraphs 4, 16 to 23 and 46.1, the judge then compounded the error in that paragraph by expressing the view that only acts of surveillance by formal CNI intelligence agents could attract immunity, and that no state immunity could be claimed in respect of contractors. But the judge was simply wrong to state in this paragraph that no state immunity could be claimed in respect of the acts of private contractors, as opposed to CNI agents. As we've seen, Article 8 of the ILC's articles and the commentary thereto make it abundantly clear that the conduct of private individuals, authorised, directed or controlled by state officials, can indeed be attributed to the state. And as Lord Bingham and Lord Hoffman explained in Jones, attribution on the international plane is symmetrical with immunity at the domestic level. Now, the one aspect of paragraph 70 which we would respectfully agree with is the judge's tacit acknowledgement that allegations of involvement of CNI agents could indeed give rise to immunity on the basis contended for. That too, given the pleadings as accurately read, only shows, however, we say, that the judge's ultimate conclusion was wrong, because there were the unequivocal allegations we've pointed to. Paragraph 71 continued in the same vein. The judge appeared to accept that the claim to state immunity could or would succeed if the alleged trespass on the claimant's Monaco property was authorised, directed and executed by CNI operatives, by saying that this would make, as the judge put it, a big difference. But then he repeated his erroneous analysis of the pleadings, saying that the precise circumstances were unclear. So again, he was finding ambiguity where there was none. And then at the end of 71, the judge repeated his error from paragraph 70 by saying there could be no conceivable claim to immunity in respect of the activities of contractors as opposed to intelligence agents, even if they were directed by the appellant. Now, that is inconsistent with Jones and the guidance we get from Article 8 of the ILC's articles. Now, the respondent says that the judge here is not saying that no claim to immunity could arise in respect of acts of private contractors. But that is, we respectfully submit, exactly what he is saying. He said it in terms in paragraph 70. And in the last last sentence of 71, he said that if it was private contractors who were directed by the appellant, no conceivable claim to immunity could arise. And that's simply wrong, particularly once General Sands-Roldan's presence on the scene is taken into account. Any requisite state involvement underpinning the private contractor's conduct would be provided both by the King and by the General. Paragraph 72, the judge addressed what he considered to be a lack of sufficient evidence about the events in Monaco. He wasn't satisfied on the pleaded case that raised an obvious case of immunity, but that view was, again, we respectfully submit, simply based on a flawed analysis of the pleading, which, as I've submitted, put the CNI covert team squarely in the frame in an entirely unambiguous manner. The judge then said that whether immunity would arise would require further investigation of, as he put it, who precisely carried out the operation and in what capacity. And he contemplated revisiting the issue later in the proceedings, pointing to the opportunity of the Spanish state to step forward and the fact that the claim would be proceeding in any event. But that paragraph too, with respect, just disclosed further errors of law. Firstly, section 1(2) of the State Immunity Act requires the court to give effect to state immunity, even if the state concerned does not appear. Secondly, it's impermissible, if this is what was going on, to stand over an issue of immunity for trial. The court has to address it as a preliminary matter. It either does that by determining it on the face of the pleadings, as we respectfully submit can easily be done here, or it does it by directing trial of a preliminary issue. That's what the case law summarised in our skeleton at paragraph 37 shows. And thirdly, it was irrelevant, as I've already submitted, to take into account, as the judge did, the fact that by virtue of his other conclusions on household immunity, aspects of the claim were to proceed in any event. That would be to convert the determination of the state immunity issue into one involving the exercise of discretion, something which Jones tells us is impermissible. At paragraph 73, the judge referred to, but did not resolve, further submissions advanced by the claimant. And those submissions were to the effect that because the trespass alleged involved criminal acts outside Spain, section 14 of the State Immunity Act could not apply, presumably because there was no formal power to act in that way. Now, in fairness to the judge, he went no further than to say that it appeared to him that the objection was well-founded. It's not well-founded. As the ILC articles and the commentary show, attribution on the international plane, and so state immunity from civil proceedings, and I emphasise civil proceedings, can and does apply to extraterritorial acts. and attribution and immunity can and do apply to acts in excess of authority or power. This is all set out in our skeleton argument at 51. And the authority relied upon by the claimant and referred to by the judge at Kurt's bat against Germany provides no assistance at all. It was a criminal case simply not dealing with this point. We then have paragraph 74 of the judge's judgment, which contains the judge's conclusions on events other than those in Monaco. And he makes 2 points here. First of all, he says in lines 2 to 7 that apart from the suspicious circumstances relating to the discovery of a book about Princess Diana, the only connection to the Spanish state was that the acts were alleged to have been carried out by General Sanz Roldan. And secondly, he says that the making of threats by a high-ranking state official did not without more make them state acts, citing Mallon and a recent decision of the Divisional Court, Fernando. But that analysis, with respect, doesn't stand up either. First, it was simply wrong to say that the only connection to the Spanish state in respect of these matters was that they were allegedly carried out by General Sanz Roldan. As we've seen, paragraph 46.1 of the particulars of claim alleges that they were carried out by the CNI operatives. Secondly, the connection to the Spanish state through General Sanz Roldan, allegedly acting at the behest of the king, is a significant and entirely sufficient one in any event. This is 1,000,000 miles away from the constable out on a Sunday night, frolic of his own scenario considered in cases like Mallon. Thirdly, this case was, at least, go back to a point I made earlier, at least in part, alleged to be occurring to protect the reputation and dignity of the sovereign and the institution of the monarchy. So to the extent that those questions of purpose are relevant, they hardly help, we say, the respondent. And fourthly, the Fernando case referred to by the judge was, if anything, inconsistent with his approach for the reasons we've given in 45.2 of our skeleton argument. Finally then, my ladies, my lord, we have paragraph 75 leading to the direction at paragraph 78, where the judge addresses the issue of amendments to the particulars of claim, stating that the claimant should make it clear that the acts alleged against General Sanz Roldan were alleged to be acts in his personal capacity, not as head of the CNI or other official capacity. And that approach too, with respect, we say, was flawed in a series of fundamental respects. Firstly, it involved and proceeded from an inaccurate summary of what was to that point alleged. Secondly, it's impossible on any common sense view to see how General Sanz Roldan could have directed a covert CNI operation and a team of agents in Monaco at least, other than in his official capacity, under colour of his authority. Or how the appellant for his part could have engaged with General Roldan other than under colour of his own authority. And as I've said, the judge gave no consideration at all to this issue. Thirdly, as I'll say in addressing the third question that I identified at the outset, the judge should at least have considered whether the proposed evolution in the claimant's case was a contrived shift to avoid state immunity, involving precisely the kind of impermissible and practically unreal severing of roles identified in both Al-Attiya and Circus. And fourthly, as a matter of procedure, there was no application to amend or even a draft pleading, both of which are required on authority, a matter I'll come to again under the third question. So to summarise, my ladies, my lord, first, nowhere in these passages of the judgment containing the judge's reasoning does he expressly refer to the question of colour or authority as providing the test for Section 14 purposes. Secondly, the judge found ambiguity in the pleading, where in truth there was none. And thirdly, the judge had regard to analytically irrelevant matters in considering the fact that the case would be proceeding in relation to other allegations in any event, and in considering and directing proposed amendments to the particulars of claim floated in argument by Mr. Lewis, but never actually formulated before him. Nothing, we respectfully submit, in the respondent's skeleton argument seeking to defend the judge's approach meets any of these criticisms. The first substantive point that Mr. Lewis makes at paragraphs 34 to 38 of his skeleton argument is to rely upon the fact that earlier in his judgment, the judge set out submissions and authorities on the concept of colour of authority. But that, we respectfully submit, does not excuse his failure adequately to address or even to refer to that concept in the material part of his judgment, setting out his own analysis and his reasoning. The second substantive point made is to rely upon the judge's reference to Circus and to Mallon at paragraph 74, apparently to assert that the judge somehow applied the colour of authority test sub silentio by reference to who it was that actually carried out the acts. But that doesn't help the respondent either, and the comparison with Mallon was misplaced, we respectfully submit, on the facts for the reasons I've already given. The involvement of a head of state and a head of intelligence is a very long way indeed from a case concerned with a deputy constable out on a Saturday night, and the judge should have so held. Consideration of colour of authority requires consideration of the whole context, including but not limited to who carried out the acts alleged. And the judge's analysis, as I've said, as to what the particulars of claim actually said as to who it was who had carried out the acts alleged, was flawed because of the ambiguity he found. And then, of course, the judge was wrong as a matter of law to proceed in the way he did in relation to the question of private contractors. Paragraph 39 of Mr. Lewis's skeleton argument accepts that the correct test is that of colour of authority, but that doesn't help either in circumstances where I've submitted the judge didn't apply it. Paragraphs 40 and 41 of the respondent's skeleton argument seek to show how the colour of authority test, as explained in Al-Attiya and Circus, could not be satisfied in the present case. But we respectfully submit, cure none of the deficiencies in the judge's approach, again, for the reasons I think I've largely given. The reliance at 41.1 on a single generalised statement by the appellant, alleged to have occurred 7 years after the events in question, about the general being a close protector and so forth, is a very weak basis, we say, upon which to meet the case that it was only because the appellant was the king that he was in a position to influence the general, and on the respondent's case, to bring about the CNI operations complained of. The invocation in the same paragraph of the skeleton on allegations of personal visits to the UAE after abdication were not allegations before the judge. At 41.1, it's again asserted that the appellant had no power to direct the intelligence services, but that's irrelevant, as we've seen from the authorities, because immunity can apply even where the act is beyond power. 41.2 relies upon the respondent's deletion of her allegations against the CNI, but that aspect was a matter not directed by the judge at all. The only direction in relation to amendment that the judge gave, wrongly we say, was to direct that an amendment be made averring that the general had acted in his personal capacity. The pleading which then emerged after the judgment deleted every reference to the CNI, again illustrating the importance of rigour and the dangers of proceeding without an application or a properly formulated pleading. 41.3 seeks to rely upon new information as to personal motive. Now, new information, if it's put before a court, sounds very much like new evidence that a court is being invited to take into account. In any event, as we've seen, as Jones, Circus, Al-Attiya all tell us, motive's irrelevant. 41.5 seems to row back to some extent from a test of colour of authority and to go back to a broader question of private law characterisation, but we respectfully submit no adequate reason is given for that. And 41.6 refers only to the nature of the cause of action, but that doesn't help in determining whether the allegations under challenge are properly characterised as occurring under colour of authority. So, my lady, my ladies, my lord, for all those reasons, we respectfully submit the appellant is correct in contending that the judge simply failed to identify or apply the correct test in his immunity analysis. His judgment contained a series of material errors in the light of the key authorities I've referred to. And the only correct conclusion is that the original particulars of claim in respect of these paragraphs did indeed give rise to a Section 14 immunity bar. Now, there's a final point on Section 14 that I should mention because of the prominence that has been given to it by Mr. Lewis in his skeleton argument. He contends that Sir Daniel Bethlehem below conceded before the judge that no case on functional immunity by reference to Section 14 was advanced. That is, we respectfully submit, an argument of no substance. And we've set out our position on this in paragraphs 52 to 53 of our own skeleton argument on this appeal. The judge made no reference to any such concession in his judgment, and he based no part of his reasoning on that. Paragraphs 19 to 20 and 26 of the skeleton argument before the judge expressly contended that many of the acts underlying the claim could be considered to be acts done in His Majesty's public capacity. The oral argument did likewise. Consistent with all of that, paragraph 35 of the judgment records submissions by Sir Daniel directly contrary to the suggested concession. As the judge accurately puts it there, Sir Daniel contends that several of the acts of harassment alleged can be considered to have been done in his public capacity. And the actual heading to paragraphs 65 to 75 of the judgment is, of course, functional immunity under Section 14, which rather suggests it was in issue. So that's question one, my lady. For all those reasons, the correct answer is indeed that the pre-abdication allegations set out in the original particulars of claim are to be characterised as acts carried out by the appellant in his public capacity. Section 14 applies, and those allegations have to be struck out. That takes me to question 2, I should say, relating to Section 5 of the State Immunity Act and the personal injury exception. And that, of course, arises on the respondent's notice, but if it's convenient to the court, I'll set out my submissions on it now. Now, before looking at the judge's reasoning on this issue, it is instructive, we submit, to see how little attention the respondent devoted to the issue when the immunity application was before the judge. That state of affairs suggests in and of itself that the reliance on Section 5 lacks merit, and that the recent attempts to amend the particulars of claim are indeed a device to convert what has in truth always been a statutory harassment claim into a personal injury claim to overcome an immunity hurdle. The immunity application was issued in June 2021. The procedural timetable allowed the respondent to serve any evidence in response by the 8th of October 2021. The first indication that the respondent was placing any reliance on Section 5 came in her skeleton argument served 6 days prior to the hearing on the 30th of November 2021, when only 4 paragraphs towards the end of that document addressed the question. At the hearing, the judge expressly put the point to the respondent's counsel that the respondent had not actually made a personal injury claim, to which the response was, it was a very small part of her position. That's day 1, page 77, lines 19 to 24, supplementary bundle, page 175. Thereafter, during the hearing, the respondent's counsel developed no further oral submissions on Section 5 and did no more than rest on what had been set out in his in the skeleton argument. Now, the judge's reasoning in relation to Section 5 is set out at paragraph 76 of his judgment. And each aspect of that reasoning, on the basis of the particulars of claim before him, and there wasn't any floating of amendments in relation to this aspect of the case, Each aspect of that reasoning was correct. First, the claim as set out in the claim form and the particulars of claim made no reference to personal injury at all. And it was, as the judge put it, one of pure harassment by reference to the 1997 Act. That's the second sentence of paragraph 76. The claim form for the court's reference referring to the Act is in the core bundle at page 116. The particulars of claim likewise made no reference to personal injury. The particulars of claim also, and in consequence, did not set out any of the particulars that the CPR would have required had this been a claim for personal injury. No date of birth, no details of injury, no schedule of losses, and so on. And there was no reference to, let alone service of, any medical report. Indeed, we now know that the respondent had not even sought such medical evidence at the time she commenced her proceedings, because the first medical report that we've now been shown dates from May of this year. So that's the first point. The judge was absolutely right to say the claim didn't refer to personal injury at all. Secondly, the references in the particulars of claim to distress, depression, and anxiety, and they're at a number of places, 5, 55, 56, and 57, were not, as the judge correctly held, without more, sufficient to convert the proceedings into proceedings relating to personal injury. And that is so for three reasons. Firstly, it is well established as a matter of law that anxiety, depression, and distress do not, in and of themselves, constitute recognised psychiatric injury. That is the point made in the third sentence of paragraph 76 of the judgment. And it's entirely correct in the light of the authorities we've cited in our skeleton argument at paragraph 61, Lord Bridge and McLaughlin and so on. Secondly, in contrast to the common law, the 1997 Act permits recovery of damages for anxiety which does not reach the level of personal injury in the form of psychiatric illness, so reinforcing the idea that that is how those references to anxiety and the particulars of claim were to be understood. And that is clear from the wording of the 1997 Act itself, which the court has in Bundle 1 at tab 2 of the authorities, and it's also a point made at first instance, at least, in the case of S&D property investments, which is in tab 13 of the authorities at page 601. Similar considerations apply in other contexts. The Equality Act, for example, permits awards for injury to feelings not reaching the level of personal injury. So that's the second point. The 1997 Act informs the correct interpretation of the particulars of claim and the references to anxiety in that regard. And thirdly, neither Jones against Ruth nor Nigeria against Ogbonna, two of the authorities that the respondent cites, provide any assistance at all on this question for the reasons given by the judge at paragraph 76 of his judgment. In Jones, the claimant was expressly pursuing a claim for psychiatric injury. In Nigeria against Ogbonna, this was a case too in which personal injury was expressly alleged, and all it established was that personal injury in Section 5 of the State Immunity Act should be given its normal meaning in domestic law. It also emphasised the distinction between a claim for injury to feelings and a claim for personal injury. So far from assisting the respondent, it stands in the way of her case. Now, the respondent seeks to challenge the judge's findings in this regard in her skeleton argument at 62 to 63 by contending that it was clear, as she puts it, that the claimant intended to claim damages for injury to her health. But that is, with respect, simply bald assertion without substance. There is, as I've said, nothing in the claim form to that effect, nothing in the particulars of claim to that effect. no pre-action correspondence actually occurred in this case at all, and so there was no question of any compliance with the personal injury pre-action protocol in that regard. Finally, to some extent in relation to this issue, the respondent also seeks to rely upon a recent decision from August of this year called Al-Attiya, a decision of Mr. Justice Julian Knowles at first instance, in relation to, again, a personal injury claim concerned with deployment of state spyware. It doesn't assist the respondent either, for 4 reasons. Firstly, the claim as pleaded in Al-Attiya was expressly for personal injury, occurring while the claimant was in the United Kingdom, and as a result of numerous acts and omissions in the United Kingdom. So materially distinct from what we've seen this claim, as originally formulated, was about. Secondly, the judgment in Al-Attiya correctly recognised that the burden of proof in showing any exception, in this case the Section 5 exception, to apply rested on the claimant, and that it was not enough for a claimant simply to establish a good arguable case that the exception applied. It will be necessary to show it did apply on the balance of probabilities. Thirdly, the judge held there had to be at least an act or omission in the United Kingdom which was causative of the personal injury alleged on a more than de minimis basis. And as we pointed out in paragraph 14 of our supplementary skeleton argument, even the respondent's late medical evidence, which the respondent appeared at one point to float the idea of putting before the court but has pulled back from, even that late medical evidence does not go that far in relation to any of the pre-abdication conduct. It makes no attempt to show causation of any injury flowing from any individual act in the United Kingdom.
Well, that raised the point I was on earlier, as to whether what we're talking about is immunity in relation to particular acts or immunity in relation to the cause of action.
Well, in relation to Section 5, you've got to show that the claim relates to personal injury caused by an act or omission occurring in the United Kingdom. That's the test for Section 5 immunity, for the Section 5 exception to apply.
Yes. So if I thought the point you were on is no causative link identified between pre-abdication acts.
Yes.
But if it were the case that a post-abdication act were alleged to have caused, in a more than de minimis way, the personal injury, then does it matter that there's no causative nexus alleged in relation to pre-abdication acts? If one's looking at the cause of action, which in harassment is a series of acts, rather than individual acts. Do you understand the point I'm on?
I think so, Noel, but you certainly, our position, you certainly can't bring in the pre-abdication allegations and allow a court to adjudicate upon them through the guise of Section 5, unless you can show that one of those pre-abdication allegations, A, caused or contributed to a personal injury, and B, occurred in the United Kingdom.
But why not? If the immunity under Section 5 attaches to the proceedings as a whole in relation to the cause of action, and if the cause of action is in harassment and involves acts which take place in the UK and, I suppose for the time being, have some the necessary causative effects, i.e. post-abdication acts, why does that stop you relying on pre-abdication acts as part of the cause of action?
Because that would be to run directly counter, we say, to Section 14, which provides for immunity for the sovereign in relation to acts occurring in public capacity.
Well, that I would understand if you had acceded to what I was suggesting earlier, that the immunity under Section 14 is an immunity from our court sitting in judgment on acts which have been committed by a head of state in a public capacity. Well, but if it's a question of only barring it sitting in judgment on causes of action, and the cause of action doesn't attract immunity because of Section 5, then I don't quite follow why your argument works.
I think I'd better go back then to the original question, as your lordship's given me the opportunity to address it twice. The first question is looking at the allegations of fact in a particulars of claim. Are they allegations of fact occurring under colour of authority?
Answer in this case, some are, some aren't.
Some are, some aren't.
Right.
Those which are have to be struck out because there is an entitlement under Section 14 to immunity from the court adjudicating upon those acts. And so it may be that in the particular context of this case, the answer has to be yes to the question my lord posed earlier, I think, about whether it bites upon acts as opposed to causes of action. I think I was perhaps grappling at a different question, which is it always off limits for a court to look at state acts, whatever the context?
Of course, it would look at them in the context of third-party claims.
Yes.
But if the claim is brought against
the relevant
the head of
person
state
entitled to immunity, then it must be the case, my lord, that yes, I'm sorry for not being clearer and understanding the question properly, but that must be the case. Otherwise, it would be meaningless, and it would allow a Trojan horse situation where a whole raft of allegations, which were, on any view, not capable of being the subject of adjudication by a domestic court, to be brought in under the umbrella of one allegation which didn't offend against immunity principle.
Well, I wonder whether there may be some authority that assists on this. On the one hand, it may well be said that the par inter parem rationale supports the view you're suggesting. On the other hand, Section 5 talks about immunity from proceedings.
Yes.
Well,
we'll have a look for that, my lord. Certainly.
I've bowled that to you as a rather fast ball. And
thank you, my lord. We'll see
if
we
you want to
can
come back on it, then I will.
As a matter of principle, in any event, I hope your lordship has our position where we stand on it. Certainly the approach, obviously it's only limited assistance, certainly that was the approach that appeared to be common ground below, appeared to be acknowledged by Lord Justice Underhill when granting permission, that if there were a discrete set of allegations which were properly characterised as triggering Section 14, then they could be struck out even if even the remainder of the proceedings were to continue.
So far as Section 14 was concerned,
yes.
Absolutely so. I'm not sure anybody focused on how that played through.
How that played? No, they wouldn't have done because we hadn't got Section 5 in play at that point. But if we go to Section 5, my lord, the starting point, before I get to the third question, is that the judge was right. There wasn't a claim for personal injury.
Yes, I understand.
And if we're right about that, then subject to the third question, that is that.
Yeah. And you're also right to say that Al-Attiya doesn't really address this because it was an all or nothing argument that was being run in that case. And
it was a case where there was an express allegation of personal injury, where medical evidence had been deployed and so on. So the claimant in that case was through the gateway already.
Well, it could have been argued in that case that the gateway only allowed through the allegations where there was some cause of effect and not those where there wasn't. But that wasn't what was argued.
It was argued that there was a whole raft of composite acts, some occurring outside the jurisdiction, some occurring inside the jurisdiction.
Yes.
And the judge held that provided some of the composite acts had occurred in the jurisdiction and had caused personal injury, some of those in the jurisdiction had caused personal injury, then that would be sufficient to allow Section 5 to be satisfied across the board.
Yes, but as I understand it, the contrary argument was everything's got to have happened.
Yes.
Within the jurisdiction.
Yes.
And that was what was rejected.
Yes.
There wasn't a fallback argument.
No.
That only that which has happened within the jurisdiction
no, that's right.
can get through the gateway.
I think that's right, my lord, yes.
Thank you. Sorry, I've diverted you.
No, I'm not at all, my lord. It's very, very helpful to have the chance to address it. The simple point for the purposes of this second question is are these proceedings in respect of personal injury? You don't even forget about where or when or whatever was caused it. The simple point is they weren't, as the judge held. So the question then, the critical question then for the purposes of the Section 5 analysis, really turns upon question 3, as I started with this morning. To what extent can that be cured before this court, or in due course at first instance, by amendments of the kind that the respondent wishes to make?
But you do say as a fallback, in any event, no allegation or evidence of causative potency between pre-abdication acts and the acts Al-Attiya relied on, and all acts outside the UK apart from the Connaught Hotel meeting.
Yes.
So you would say as a fallback, if you do slice it,
yes,
either all or almost all of the pre-abdication acts fall outside Section 5 for those reasons.
Yes.
Have I understood it?
Yes, my lord. And you certainly couldn't reach a conclusion that, and this again goes back to the importance of procedural rigour, you couldn't reach a conclusion that the Section 5 exception was satisfied because it's necessary for a claimant to establish that it is satisfied on the balance of probabilities. And so if there is to be a debate about Section 5, it has to take place at first instance. And that's particularly obviously the case in the context of a claim where, as I say, the medical evidence doesn't actually purport to show anything about causation in relation to events in the United Kingdom, and where it might be the case that a preliminary issue trial could be held about the events at the Connaught Hotel, being the only allegation said to have occurred in the United Kingdom for the purposes of Section 5 purposes. So all of that illustrates that it will be completely incoherent procedurally to invite the appellate court to grapple and resolve all of this, and with respect, frankly, unfair to a party facing proceedings to take that course when amendments are only proffered in the way that they have been. So I'll turn to that third question, that critical third question, if I may, next. Whether it was open to the respondent to strengthen her hand on Section 14 by reference to possible amendment of her particulars of claim when the matter was before Mr. Justice Nicklin, whether it is open to Mr. Lewis now to do so in relation to both Section 14 and Section 5 by the deployment of a yet further draft pleading, embracing new and as yet unevidenced assertions. And I emphasise in this regard at the outset a matter which is again now common ground, but which didn't appear to be common ground below and certainly didn't feature in the judgment below. If, in response to a plea of immunity, a claimant proposes amendments to his or her claim, the court considering the plea of immunity has to, at a minimum, consider whether the proposed amendments are contrived as a device to avoid the plea. Now that much is now accepted by the respondent at paragraph 23 of her skeleton argument, and again is correct as a matter of principle and authority, having regard to the sensitivity of the state immunity context and the guidance provided by cases such as Al-Attiya and Circus. And as I've said, our overall position is that it was wrong for the judge to proceed in the way he did, and it would be equally wrong for this court to take the latest new material into account. Now, as I said earlier, that would not preclude the respondent from issuing an application at first instance to amend her pleading in whatever form she chose to. And we would have to meet such an application as and when it were made. But such a proposed amendment could only be considered, we say, only be considered in a procedurally coherent and fair manner at first instance, on the basis of an issued application, on the basis of evidence from the respondent, not correspondence or even correspondence corrected by Mr. Lewis, so that the appellant knows the case he has to meet.
And is that because there's a merits test involved in an application to amend? That you need to show on any application to amend that you have a reasonable prospect of success, which has been interpreted by the authorities as meaning something carrying a degree of conviction.
It's partly that, my lord. It's reinforced in the particular context of state immunity because of the importance of procedural rigour flowing from the sensitivity of the context. And it's reinforced because of the test I identified earlier, that where a plea of state immunity is made, the court has to say to itself, well, hang on, is this just contrived to get around the state immunity plea that would otherwise succeed? So it applies generally in relation to amendments, particularly late amendments, that you've got to show some merit to your position. But it applies particularly in this context because of the sensitivity of state immunity, see Lord Lloyd-Jones in General Dynamics, and because of the test which applies on amendments in a state immunity context, is it contrived or not, see Circus and Al-Attiya.
Well,
And
I wonder whether that first instance authority establishes some separate principle that in state immunity cases you've got to apply a test of whether or not it's contrived, whether that isn't simply an example of application of the general principles on amendment, that generally they have to be formulated and in a way which is coherent, and that there is a merits test, and that although there may well be cases in which you can dispense with all that formality because it's obvious that the formality is unnecessary, where that isn't obvious, then the tests are the amendment tests, not some test which is peculiar to the context of immunity.
Well, I do say there's a particular sensitivity in the immunity context which requires procedural rigour over and above the procedural rigour which would apply in any litigation, my lord. Because what is being asked is for the courts of this jurisdiction to sit in judgment, ex hypothesi on this argument, on a claim which would otherwise be barred by state immunity.
So it's because the court has to make a judgment at a threshold stage as to whether the case goes ahead on the basis of the pleadings.
Yes. Or a trial of a preliminary issue.
Or trial of a preliminary issue
if appropriate. And we say, my lord, none of these matters can properly or fairly be grappled with by an appellate court without being considered below. And they show why it will be wrong in principle for this court to have regard to the draft pleading now presented. Now, with that introduction, I'd like to start again by emphasising what we submit to be the rather strikingly informal nature of events below. The immunity application, as I've said, was issued in June 2021. The first hint at a change of tack on the respondent's part came again shortly before the December hearing with the respondent's skeleton argument. Not because that skeleton argument actually said that some sort of amendment application might be made or amendments might be needed, but because the respondent in that skeleton argument appeared to emphasise an alleged personal relationship between the appellant and General Sans Roldan for the first time, describing the General as a personal associate of the appellant, and describing, at least in that skeleton argument, if not the pleadings, describing the entry into the respondent's properties as having been carried out by private investigators. But as I say, even then, even at the stage of the skeleton argument, there was no suggestion of any amendment being made to the particulars of claim. That came during the course of the December hearing itself, on the second day of that hearing, during the course of Mr. Lewis's oral submissions. On day 2, page 28, this is supplementary bundle 205, it was said by Mr. Lewis that when the General travelled to London, he was on a private mission. The supplementary bundle, page 205, lines 25 to 32. Mr. Lewis acknowledged that, unfortunately, it wasn't pleaded that way, and he recognised that it might be that the respondent would have to amend her pleaded case to say, in a private capacity. Now, at that point, and no doubt on instructions, Mr. Lewis told the court that the respondent actually had reports, this is the point I flagged earlier, had reports that the General had admitted that he'd travelled to London in a private capacity. Now, just pausing there, as I emphasised earlier, we've heard no more about that in any of the 3 iterations of the respondent's particulars of claim to be produced since that hearing. And that again suggests considerable caution should be applied in any consideration of draft pleadings or other assertions produced without explanation on or evidence. Still on day 2, in the same passage just over the page, Mr. Lewis contemplated striking out the entirety of the allegations relating to the pre-abdication conduct, stating that the respondent could live without them. And then there are further references to the potential need for amendment made during the hearing on 3 further occasions by Mr. Lewis. But at no point is a draft pleading actually produced.
What do you draw from the fact that Mr. Lewis said he could live without it? So
well, one of the arguments relied upon on the question of unagreed material, my lady, and the appropriateness of this court considering it, is to say, and we've addressed it in our supplementary skeleton argument, is to say, well, Ladd and Marshall doesn't really apply. It's all about the overriding objective. And so if, in fact, these are really just peripheral allegations that the respondent can live without, that flows into the correct analysis of where the overriding objective lies, or what it suggests is the fair outcome. Now, of course, we are where we are, and the fact that Mr. Lewis and I are here for a day suggests there may have been a degree of understatement in the "we could live without it" observation before Mr. Justice Nicklin. So I don't want to take it
we don't want to.
too far, exactly.
What I think you can say is that because Mr. Justice Nicklin sought to pin him down a bit on what was being said, and was putting to Mr. Lewis that if there were references to CNI involvement,
Yes.
it would be difficult to see how the case
Yes.
could get over
Yes.
Section 14.
Yes.
Which Mr. Lewis seems to be saying, well, I would probably accept that.
Yes.
And therefore there was a recognition on his part that if CNI involvement were to continue to be part of the case, they might have to accept
Yes.
passages be struck out.
Yes.
And that there wasn't any indication at that stage that he thought that the CNI involvement was something which factually could be eliminated from the case. Although when the amendments came forward, that was what happened.
Yeah, it's fair to say later on he does appear to contemplate striking out, Mr. Lewis appears to contemplate striking out allegations against the CNI as well in later passages in the transcript. But all of this illustrates, and I go back to the point I emphasised right at the beginning, the dangers of proceeding in this way. The court had before it a particulars of claim making unequivocal allegations of CNI involvement, state intelligence involvement. Everyone appears to be gravitating towards a position, obviously Sir Daniel Bethlehem, and in addition Mr. Lewis and the judge, gravitating towards a position that those allegations give rise to problems in terms of state immunity in Section 14. And the correct procedural response to that is not to simply say, oh, well, I'll ditch all those allegations, or I'll continue to rely upon the same allegations of trespass and search and seizure, but I'll just strike out the word CNI. Because how do you explain the statement of truth? How do you allow a claimant who's put forward that case on the basis of her own statement of truth, consistent with her earlier affidavit in Spanish proceedings, to take that approach? On any sensible view, we say, there would have to be an application to amend, explaining what had gone on before, explaining the course that was being taken going forward, and then seeking to assert and justify why that was consistent either with amendment principles generally, or amendment principles with the asterisk that I would submit is appropriate in a state immunity context, whether by reference to general dynamics or Circus and so on. What you can't do in a procedurally fair or coherent way is allow this informality of approach. Now, the judge addressed this issue of the amendment in 3 passages in his judgment, which the court's already seen, I think, 2 of them at least. At paragraph 53, this is core bundle page 107. he referred to Mr. Lewis's offer to remove, as he put it, any doubt about whether state-sponsored actions or public capacity conduct on the part of the general were alleged, by stating that the respondent would be content to make it clear in her particulars of claim that the general was acting in a private capacity in respect to the acts alleged against him. So, although, as I've said, in fairness, in the course of argument, there was reference to the possibility of deleting reference to the CNI, by the time it comes to the judge's judgment, all of the focus is on the general and private or public capacity so far as the general is concerned. So that's paragraph 53. And then 75, which the court's already seen. For the sake of clarity in the future conduct of the claim, the respondent should make it clear the acts alleged against the general were said to be acts in his personal capacity, not as head of the CNI or other official capacity. And then again at paragraph 78, in the interest of clarity, the respondent will be required to amend her particulars of claim in this way. Now that approach, as I've submitted already, was we respectfully submit, flawed in fundamental respects. It ignored basic procedural rules about how pleadings were to be amended in any context. It ignored the particularly sensitive context of sovereign immunity. And it made no effort, whether as part of that first question or otherwise, it made no effort to apply the test which the respondent now accepts at paragraph 23 of her skeleton argument is the proper one, namely whether the amendment is in truth a contrived attempt to avoid a state immunity barrier, or whether, as Mr. Justice Carver put it more vividly perhaps, whether what was going on was dancing on a pinhead to avoid a state immunity plea.
What's meant by contrived in this context? Sorry to come back to a point I had earlier. And a device. If it is plainly intended to meet the problem which has been recognised about state immunity, but nevertheless there is an evidential basis which meets the merits test, is that a contrived device? Does that mean you can't make the amendment?
If there was a good faith amendment being proposed, my lord, which showed that on proper analysis then immunity wouldn't apply, then that might well meet the case on immunity. But you can't, this court simply doesn't have the tools to address that question. And nor do Mr. Justice.
So you say the test is whether it's being put forward in good faith or not?
Well,
I wonder whether you're putting that a bit higher. I have some difficulty with this concept of a contrived device as a separate test, because I can see that it may well be that the motive is a realisation that there's an immunity problem, but it may nevertheless be a proper amendment, and whether or not it's a proper amendment must surely be governed by the principles that apply to amendments generally.
My lord, yes, but wouldn't necessarily answer the ultimate question as to whether immunity applies, because the ultimate question about application of immunity on the basis of whatever a pleading is before the court is to consider the case in its overall context and see whether state immunity is in play or not. And that overall context would have to consider the various iterations of the case. And in this case, well, we don't shrink from contending that this is an insincere device on the respondent's part, this approach to amendment of pleadings. And we've set out in our supplementary skeleton why we say that is so. None of it makes sense chronologically. All of it makes sense only absent an explanation from the respondent herself in evidence explaining an evolution in her understanding or why she's changing her factual allegations.
No, I understand that's what you say, the circumstances, but I'm just feeling my way towards what is the test which you're asking this court to say would need to be met, and you said it's contrived device, i.e.
Yes.
Bad faith.
Yes.
And I wonder whether that, as a test, although you say it's met, it's putting it too high.
Maybe I don't.
That's all I'm exploring with you.
That's the question of is it contrived is the test that was applied, at least by Mr. Justice Carver and Mr. Justice Blake. Is it unreal? Might be another way of putting it. And in the context of their cases, Mr. Justice Blake first, then Mr. Justice Carver, they were essentially saying you can describe the conduct in a different way, which if you can find your consideration to the four walls of that particular document might not give rise to an obvious state immunity problem. But once you look at the matter in context, as a matter of substance and reality, it is a device.
Well, or you could just apply the law generally in relation to amendments, which are, they must meet a merits test, which means they have a degree of conviction.
Yes, and that isn't satisfied. That isn't satisfied here either. So we would say the respondent fails at that lower bar and fails, if we needed to, at the higher bar too. If the judge had applied either of those tests, there could have been no basis for finding the change of course floated by Mr. Lewis to be a proper one. The respondent had signed her statement of truth on the previous pleading, consistent with her earlier sworn affidavit, and she was now apparently proposing to advance a diametrically different case in the face of a state immunity challenge, without any evidenced explanation at all. Take a completely different context to remove the state immunity context for a moment. Assume a claimant had pleaded in a personal injury claim that an accident had occurred on a particular date that was actually outside the 3-year limitation period. And the defendant responded by saying, well, this is time barred. And the claimant then simply responded by saying, oh, well, I'll amend to say it was within 3 years, without any explanation at all about why the statement of truth given earlier was actually wrong, or why an error had been made. The court wouldn't allow that, we respect this. And that's, in a sense, the first and basic point we make about this. It's in our skeleton at 48.2. There's a need for formal applications in respect of amendments. That's this court's decision in Magdev. The second point is the one I've already made a number of times. There is a particular need for rigour in the sensitive context of sovereign immunity. That's Lord Lloyd Jones in General Dynamics, which we refer to at 48.4 of our skeleton argument. A different context, of course, I accept. That case was all about the ability essentially to order alternative methods of service to bring a state before the court. And in that context, the court said no, there was section 12 of the State Immunity Act which provided a mandatory means of service. But the general point made as to why that was so, we say applies here. The third point, there was a failure to consider any of this by the judge. Now, it may be, in fairness to the judge, that he thought all he was doing was allowing curing of an ambiguity, and so it was all very straightforward stuff. But as I've already submitted, there was no such ambiguity. And then the fourth point, again, is a point I've already made in argument. There was no material before the judge capable of justifying such a radical amendment to the respondent's case. On the contrary, there was a sworn affidavit from the respondent in the Spanish proceedings before the court alleging CNI involvement. There was the signed statement of truth, and there was the fact that the potential for amendment only occurred at such a very late stage during the course of argument on immunity. So the only inference, we say, from the material before Mr. Justice Nicklin, as matters stood before him, was that this was indeed a contrived attempt to avoid and tailor a case. And certainly there was nothing sufficient to satisfy basic principles in terms of amendments. So against that background, the judge really had only two courses open to him in the light of Mr. Lewis's desire to amend. He either had to say, no, sorry, too late, as Mr. Justice Blake had, and determine the issue by reference to the particulars of claim, or he could have adjourned the proceedings, I suppose, and said, well, no, I'm not going to resolve it in the informal manner you suggest. Make your application and we'll all see where we go. The one thing he couldn't do was allow the floated amendments to the ride to the rescue of the respondent. Now, what then of the position before this court. We've addressed this in our skeleton argument dated the 17th of October, which the court has, as I said earlier, in the supplementary bundle. In the unagreed bundle at tab C1. And the application notice to put in this new material is in the same bundle at tab A. Looking at our skeleton, we say that analytically, notwithstanding the exchanges earlier this morning, the nature of the exercise the respondent engaged in is indeed to put new evidence before this court. And it can't be the case that a party to an appeal before the court can avoid what is in substance going on by the device simply of putting in a draft amended pleading. If we look at the justification given for the application in paragraph 2 of the application notice, we've addressed it ourselves, that justification I should say, in paragraph 3 of our supplementary skeleton. The first point relied upon by the respondent is to the effect that their pleading contains, as it's put, new information. But that merely demonstrates that this is in substance an application to adduce new evidence.
Well, I wonder if you're tilting at windmills a bit. As a result of the exchange we had earlier, as I understood Mr. Lewis, he was only relying on this material, and the application is only an application to put the material before the court, not an application to rely on fresh evidence. But as I understood him, he was saying there were only two aspects on which he was relying on it. The pleading itself, for the purposes of saying this is the case we want to run, not this is an evidenced case, or this is evidence of the truth of the content of the pleading. And secondly, the contents of the letter, whose date I've forgotten, but those 3 paragraphs which purport to have an explanation as to why the position has changed. And so far as new evidence is concerned, I think the purpose of this material is limited to the latter. Have I got that right, Mr. Lewis?
Precisely.
Well, if it's not relied upon to meet our section 14 argument, I don't need to address it for that purpose. If it is relied upon, well, if not relied upon for today's purposes to meet our section 5 argument, I don't need to rely upon it. I don't need to address it. And where we end up is where I submitted earlier is the only correct destination as a matter of law and the only coherent and fair one as a matter of procedure. Namely, we win on section 14. The allegations are struck out, and it's then down to the first instance court to consider, in the context of the ongoing proceedings, whatever application to amend in its final form, with whatever final explanation is given, Mr. Lewis intends to put forward.
Yes, I'm wondering whether you need to say any more at this stage and just reserve the right to come back and reply, because if all Mr. Lewis is saying is this material shows this is the case we want to run and why it is we now want to run it, you say so what?
Yes, it's jolly interesting and gives us advance notice of a debate to happen on another day. And we've set out our detailed objections in the supplementary skeleton, and so unless the court does wish me to go into any more detail, I will leave it there.
No, I don't think so.
By more my luck than judgment, I finished 1 minute before my anticipation.
Make good use of your extra minute, Mr. Lewis. Yes.
My ladies and my lords, the principal question that this court has to determine is whether, in its context, the course of harassment complained of by the complainant was carried out by the defendant pre-abdication in exercise of sovereign authority or the purported exercise of sovereign authority. We accept that on that position.
So sovereign authority is the same as public capacity, is it, from your case?
My Lord, I'm going to take you to some authorities which explain the difference between the immunity which applies, and if I'd be forgiven for using the Latin, because it's the one which is used in all the cases, the ratione personae and the ratione materia. What is probably synonymous is in a public capacity, which is the same as functional immunity, which is the same as immunity ratione materia. They're all interchangeable.
Which is the same as sovereign authority, which is the expression you used. Is it? I'm only just picking up on your wording. If you'd said in a public capacity, then I wouldn't
Yes.
have cavilled. But you seem to be introducing a gloss on the statute at the very beginning.
It's almost exactly the same, but there are some minor points which I don't think I can say that make them completely synonymous. Can I just...
Well, if they're not synonymous, why is the question sovereign authority rather than public capacity, which is what Section 14 talks about?
Well, my Lord, for these purposes here, we say that there was no action in public capacity. And when we look at how that should be considered by the court, there's some very useful guidance in the case of Pinochet. Can I just try to put it as
I'm sorry to be difficult, but you've said the principal question is whether the pre-application acts were in the exercise of sovereign authority. It is actually the question as to whether they were in a public capacity.
My Lord, yes.
And you do say that at 23. You say, undertaken by the defendant in his public capacity as King of Spain under colour of authority, rather than private
My lady,
acts.
that's right. In other words, was the alleged conduct of the defendant pre-abdication carried out as part of his official acts or official functions as head of state? Or is the alleged conduct carried out as private acts? Now, my learned friend is driven to...
Sorry, I'm going to cavil now. I'm very uncomfortable with the word official.
I'll show you in the authorities, my lady, that the official act, the official functions, would be synonymous with, we say, public capacity, synonymous with what is otherwise termed functional immunity, synonymous with what is otherwise described acts ratione materia.
So why are you using the different words? Sorry.
So what, you're just wanting to...
If they're all synonymous.
I was going to explain that these words are interchangeable, so that when we see them in the authorities, the court is aware that sometimes they're described as, and as the judge below sometimes called it, functional immunity. It's sometimes described as immunity ratione materia. And it's sometimes, in a context here when we're talking about section 14.1, dealing with public capacity, we say they all mean the same. So there was no distinction between them.
My concern about the use of the word official was it seems to give it, potentially, would appear to give it some sort of credence and approval, when we know from the authorities that we've all looked at, is that it can be in the public capacity without it being from the worst of all possible motives.
Well, as you
so
know,
that was my concern about the use of
that's
the word
right.
official.
If I may respectfully, that's exactly right. It does have to be official, and we'll see that from the authorities.
All right. Well,
So,
Well,
Just-
ostensibly
Yes.
or apparently official,
correct,
not actually official.
correct.
That's my
That's perhaps meets my lady's concern.
Yes. My learned friend is driven to argue in this case that the only inference from the pleading, notwithstanding the pleadings expressly disavow such a position, is that the pleading alleges the course of conduct complained of was an official act or acts carried out in the defendant's official capacity, pursuant to his function as head of state, or at least ostensibly so. The position for my learned friend to succeed is that the defendant must enjoy, and I'm going to descend now into the different synonyms, so the court understands where they're coming from. Must enjoy, if it's described as functional immunity, ratione materiae, official acts, in respect of the harassment alleged in the pleadings. And we do say that the judge was entirely right below to dismiss this claim in such trenchant terms. The legal position is, we would respectfully say, straightforward. Only if the defendant was carrying out the course of conduct of harassment against a person with whom he'd had an intimate personal relationship in his public capacity can functional immunity arise. And until that hurdle is overcome, sections 14 and sections 1 of the State Immunity Act are not engaged. Because he is a former head of state, section 14 is not engaged unless the actions carried out while he was head of state were in his public capacity. That is clear. He can have no immunity relating to his present status. The immunity arises because he carried out acts or functions, official or ostensibly official, for the Kingdom of Spain. That is where the immunity arises from. And so, before I turn to the pleadings, can I just clarify some principles which I hope will assist the court in carrying out this analysis. And first, the principle underlying functional immunity. The principle underlying it is twofold. First, to sue an official of a state in respect to a state's business is indirectly to sue the state. Secondly, and the principle which has already been mentioned by my Lord Justice Popplewell, the fundamental principle that all states are equal and one does not adjudicate on the affairs of another state. Now, can I just make that good? Can I just show you the case of Pinochet? If we go to, I only seem to have 3 volumes. Why we all have different numbers, perhaps they're different pages.
Pinochet is in our first one.
It's Pinochet is tab 10. And can I first, to make good the submission I've just made in express terms, can I first of all take the court to the speech of Lord Phillips, which is at bundle page 519, report page 286. And just between A and B. There would seem to be 2 explanations for immunity ratione materiae. So perhaps I expressed it inelegantly earlier, where Lord Phillips is talking about immunity ratione materiae, that is the same as functional immunity, that is the same as in his public capacity. The first is to sue an individual in respect to the conduct of the state's business is indirectly to sue the state. And the second explanation for the immunity is the principle it is contrary to international law for one state or a state official is to adjudicate upon the internal affairs of another state. So those are the 2 principles which underlie it. And can I just go back in Pinochet, because it's very helpful just to understand where we are at the moment. If we go back to the speech of Lord Brown-Wilkinson at 202, that's bundle page 435. Lord Brown-Wilkinson sets out the position in relation to former heads of state.
I'm so sorry, I missed the page number.
I'm sorry, my lord, it's bundle page 435, report page 202. can I pick it up just below D? The continuing partial immunity of the ambassador after leaving post is of a different kind from that enjoyed ratione personae while he was in post. Since he is no longer the representative of the foreign state, he merits no particular privileges or immunities as a person. However, in order to preserve the integrity of the activities of the foreign state during the period when he was ambassador, it's necessary to provide that immunity is afforded to his official acts during his tenure in post. Now, just pausing there, my lady will see that it's here described as official acts, and that is what will permeate through this point. If this were not done, the sovereign immunity of the state would be evaded by calling into question acts done during the previous ambassador's time. Accordingly, under Article 39.2,
that's a commentary on the wording of the Vienna Convention, isn't it?
It is.
About the exercise of functions as a member of the mission.
My Lord will see this is carried through to functions of head of state.
Right.
So, if we drop between E and F, well, just picking up there. Accordingly, just against E, under 39.2, the ambassador, like any other official of the state, enjoys immunity in relation to his official acts while done while he was an official. This limited immunity, ratione materiae, is to be contrasted with the former immunity, ratione personae, which gave complete immunity to all activities, whether public or private. In my judgment, at common law, a former head of state enjoys similar immunities, ratione materiae, once he ceases to be head of state. And he then loses immunity, ratione personae, and at G, as ex-head of state, he cannot be sued in respect of acts performed whilst head of state in his public capacity. So that's where we pick up the words which are in 14.1 of the State Immunity Act. Thus, at common law, the position of the former ambassador and the former head of state appears to be much the same. They both enjoy immunity from acts done in performance of their respective functions while in office. So one has to look at their official acts and their functions. And if we go over the page to final page 436 between E and F, picking it up accordingly, this is in relation to the necessary modifications of section 21. Accordingly, the necessary modifications which tend to be made will produce the result the former head of state has immunity in relation to acts done as part of his official functions when head of state. Accordingly, in my judgment, Senator Pinochet's former head of state enjoys immunity ratione materiae in relation to acts done by him as head of state as part of his official functions of head of state. If we then go to Lord Gough, in similar vein, bundle page 210, it's the passage I think the learned judge quoted, bundle page 443, just above C. The effect is that a head of state is under the statute, as at international law. He enjoys state immunity ratione personae as long as he is in office. After he ceases to hold office, will he enjoy the concomitant immunity ratione materiae in respects of acts performed by him in exercise of his functions as head of state. The critical question being whether the conduct was engaged in under colour of or in ostensible exercise of the head of state's public authority. And the monograph of Sir Arthur Watts is set out. At the end, in this context, the contrast is drawn between governmental acts, which are functions of the head of state, and private acts, which are not. If we look at Lord Hope, he's at 241 in the bundle, page 474. The section on state immunity begins bundle page 240, just between E and F.
Sorry, just before we leave page 210, I see we also get par into par an explanation from Lord Gough.
You do, Lord.
Just between E and F.
You do. At 240, the passage on state immunity begins, and at 241, that's bundle page 474. Again, Lord Hope draws reference to Article 39.2. Just so your lordships know, 39.2 in the Vienna Convention simply is in very material terms saying you only have immunity for acts carried out in performance of the function of your office. If we drop down between C and D, and this is important, my lord, we say. He's asking about
That's my
immunity.
fault. I've lost which page you're on now.
Sorry,
No, it's entirely my fault.
241
Thank you very much.
between C and D.
Thank you.
In particular, Lord Hope posits the two questions at C, 1 and 2, and answers it just above D. As to the first of these two further questions, it's plain that the functions of the head of state will vary from state to state according to the acts which he is expected or required to perform under the constitution of that state. In some countries which adhere to the traditions of constitutional monarchy, these will be confined largely to ceremonial or symbolic acts which do not involve any executive responsibility. In others, the head of state is head of the executive. If we then drop down a few lines, just between E and F, in my opinion, the functions of the head of state are those which his own state enables or requires him to perform in the exercise of government. So pausing there was evidence before the judge below as to what the functions of the King of Spain was. He is a constitutional monarch who has no executive functions. So when you're looking about whether you're acting pursuant to your official functions or even under colour of your official functions, you have to have reference to what those functions are, and as Lord Hope says, under the Constitution here of Spain. So, dropping down between F and G, as to the second of those questions, I consider that the answer to it is well settled in customary international law. The test is whether they were private acts, on the one hand of government or governmental acts, done in the exercise of his authority as head of state on the other. It is whether the act was done to promote the state's interests, whether it was done for his own benefit or gratification, or was done for the state. And we drop down, he does mention, the critical test seems to be whether the conduct was engaged in under colour of or an ostensible exercise of the head of state's public authority. If we go over the page 242, he deals with the functions of the head of state. And between B and C, the new paragraph, it may be said that it is not one of the functions of the head of state to commit acts which are criminal according to the laws and constitution of his own state, or which customary international law regards as criminal. But I consider that this approach to the question is unsound in principle. The principle of immunity ratione materiae protects all acts which the head of state has performed in the exercise of the functions of government. The purpose for which they were performed protects these acts from any further analysis. There are only two exceptions to this approach which are customary international laws recognised. The first relates to criminal acts which the head of state did under colour of authority as head of state, but which were in reality for his own pleasure or benefit. The examples which Lord Steyn gave of the head of state who kills his gardener in a fit of rage, who orders victims to be tortured so that he may observe them in agony, seem to me plainly to fall into this category, and for this reason lie outside the scope of the immunity.
Is that a convenient?
Yes, my lady, yes.
That's the passage that Lord Hoffman in Jones said he didn't agree with.
Exactly, it does. We've brought along copies of Pinochet number 1, so you can see exactly what Lord Steyn said at page 115.
But given the unanimity in Jones, is the passage you've just been reading to us something you can treat us to all?
There is one caveat. Lord Sumption, in the case of Ben Carbuche, says that there may be occasions when motives inform the juridical character of the act. That's at paragraph 8.
Should we look at that after the short?
We can look at that on.
Sorry.
All rise.